All right, I think we'll go ahead and get started, everyone. Thank you for joining us for this second session of a very different ACC South Carolina chapter annual meeting this year virtually. We are so glad that Jim Gilliam was able to join us today on this very timely topic. And we greatly appreciate Burr Foreman McNair for sponsoring our chapter and also stepping up to sponsor this session for us. A couple of things to note in the chat box, I've also put them there. We will have a survey question at the very end of this webinar that attendees are required to answer. That's for your CLE verification, just to make sure we have you on record as here. And that will be at the very end, so be sure to stay tuned until that last second. Also, let's see here. Q&As, yes, so if you'd like to submit some questions, you can do that in the really nifty Q&A button in Zoom webinars. All questions, we'll save those until the end and have a little Q&A session towards the end of this session. So without further ado, I would like to pass to Jim and tell us a little bit more about you.
Well, thank you, Kelsey. Thank you for having me. My name is Jim Gilliam, as Kelsey said. I work at Burr Foreman McNair. I'm an attorney in the Greenville office. I primarily practice in the area of labor and employment, but also do some business litigation as well. You guys are probably familiar with our firm, but I will give you just a little bit of background about who we are. We have approximately 360 attorneys, over 19 locations across the Southeast, and we're a full service law firm. So we can help you with any sort of legal problem that you have. In terms of my background, just a little bit about me. So I've been with the firm for over 10 years now. I actually started at McNair Law Firm. And then when we merged with Burr and Foreman a couple years ago, I became part of Burr Foreman McNair. Prior to working for Burr Foreman McNair, I had a clerkship for 2 years. I clerked for Kay Hearn, and I was really lucky. I was lucky to clerk for her, certainly, but lucky to clerk for 1 year at the South Carolina Court of Appeals and 1 year at the South Carolina Supreme Court. So with that, we'll get started. So these presentations are different. I do have a little bit of background today. I actually thought Kelsey was asking me the question about this artwork that's over my shoulder. My kids did that for me, so I'm appreciative of that. I'm sure everybody can tell exactly what they are. I have twins who are 4 years old. We have a monster over my left shoulder that my daughter Layla drew, and my son George draws only one thing, which always kind of makes me laugh. He only draws Shiny from Moana. It doesn't matter how many art projects he has, that's all he will draw. You can ask him if he wants to draw something else, he will respond with no. That's all he likes to draw. So thank you to them. So with all that out of the way, let's get started, and we'll proceed with the longest title of any presentation I've ever done. It's called Culture Shifts: How EFMLA, Remote Workers, and Safety Protocols Are Recreating the Workplace. I'll be honest with you guys, the idea for this presentation was really born out of frustration as much as anything else. In talking with the clients that I represent and just people in general, it's pretty clear to me that people are frustrated about COVID-19, particularly the problems that have been thrust upon them by virtue of COVID-19. From our perspective, from a legal perspective, I think we've done a good job, not just people in my firm, but people at all firms have done a good job in terms of getting out there and trying to educate companies about what the new laws are. A big part of COVID-19, of course, there's been new legislation that's been pretty dramatic. We've talked a lot about Families First Act, we've talked a lot about the leave entitlements that are associated with that, paid leave entitlements with that. So those are monumental changes. But maybe we've been focusing on those legal issues a little bit too much. As the pandemic has taken hold and we've unfortunately realized that it's going to be here for a while, it's not going to be a short time. I know there was a time period that I was working at home, and I think others probably thought this as well. I was naively under the impression that we were going to go indoors for a month or 6 weeks and we were going to come back out and everything was going to be the same. I never imagined a world where something like college football could be in doubt. Or we could have no fans at college football. So it's been a dramatic change. Recently have been thinking a lot about the problems that have been posed by coronavirus, thinking a lot about the problems that employers are facing. And I wonder if we're kind of missing the big picture sometimes. And I think the big picture is culture, and that's kind of the thesis statement for this presentation today. But I think a good way to start this presentation is, and don't adjust your screens at home, you're right, that those are the lyrics from We Didn't Start the Fire by Billy Joel, the last verse in particular. It's a long song. If I were to put all the words up there, I don't know that this PowerPoint could even hold that. But I think this is a good metaphor to start our discussion today. We Didn't Start the Fire is, of course, a song about frustration. In the song, the narrator is frustrated about all the problems that are in the world, and all these problems too that are not something of his own creation or people who are his contemporaries, yet they have to solve these problems. And I think that's a good way to start our conversation about coronavirus. Incidentally, I'll say this, I look forward to the time where we don't have to do everything virtually and we can do things face to face. I propose that we have a happy hour and go to a karaoke bar. There are always at least one or more persons who say they know all the words to We Didn't Start the Fire. That always impresses me. So when we're talking about the new problems that we have to deal with, we talked a little bit in the opening about some of the new problems. I mean, at the second bullet point, Congress has passed new laws to comply with. That's been a drastic change, and not just any old laws. Paid leave entitlements. We've never seen laws like this. I would caution everybody, or say, and I'm maybe going to talk about this a little bit more detail as this presentation continues forward. But 12 weeks, which is the maximum amount of leave someone can get under the Families First Act, it's not such a long period of time. Of course, the paid leave entitlements are supposed to end on December 31st, 2020. I'm sure one question on the forefront of everybody's mind is it going to be extended? I would like to know too. I don't think we know the answer to that right now. We'll see, I suppose, is the best answer. But 12 weeks isn't a long period of time. And also to the extent that, your companies are looking at you and they're saying, hey, we're having to pay out all this money from a paid leave entitlement perspective. There is a silver lining. Silver lining, of course, is that, the company gets tax credits for it as well. So just something to keep in mind. The third bullet point has probably been the biggest change for everybody. We just can't do things the way we used to, can we? I mean, nobody's work environment is functioning the way it was prior to February, March, or April of this year. It's just not. I mean, whether we're talking about internally or externally. I mean, internally for employees, we've got new rules at the workplace, right? More than likely. Maybe we require employees to wear masks. Maybe we require social distancing. Maybe we require temperature checks. In terms of how we interact with our customers to provide, our services or to provide our products. I mean, we've probably got new ways to do that too, new protocols to deal with. And I think change has always been hard. And there's been a lot of things that we've had to change really quickly. And some of the problems that we're dealing with by virtue of coronavirus, some of them have legal answers, right? Whenever we're talking about, for instance, an employee, let's say we have an employee who is experiencing symptoms of COVID-19 and is actively seeking a medical diagnosis. Well, there's a legal answer to that problem. That person's entitled to paid sick leave, right? Up to 80 hours of paid sick leave. And there are of course 6 reasons in which employees could be entitled to paid leave under the Families First Act. So the Families First Act, it gives us some of the answers. It tells us, whether employees are eligible for paid leave, how long they're going to be on paid leave, and how much money they're going to receive. So that's kind of one set of answers. We may have ADA solutions to some of our problems to the extent that we're talking about an employee who has a disability. But the law is not going to answer all of the problems that we're going to be confronted with or have been confronted with during coronavirus. I've identified a couple of hypotheticals here. I say hypotheticals. I mean, these are situations that I've dealt with in helping employers. And there's a myriad of different situations that I've experienced beyond these 2 examples. And I'm sure you guys have experienced them as well. And the long and short of it is there's not legal answers to these type of problems. Both of these hypotheticals, they're rooted in fear, right? What are we going to do when we have an employee who comes to you and says, I'm afraid to come to work. I'm afraid to come to work, not because of some sort of condition that I presently have, but it's because I'm at an advanced age, or it's because I have a certain medical condition, like I've got a compromised immune system. I'm afraid of what might happen to me if I get coronavirus 19. What are we going to do in that situation? The law doesn't respond to that question for us. But, a kind of variation of that question is the second bullet point. What are we going to do when an employee comes to us and says, I can't come to work. Can't come to work because I'm afraid. I'm afraid that I'm going to get coronavirus and I'm going to give it to somebody who I live with who's at risk. Either they're older or they've got a compromised immune system or whatever the case may be. How are we going to respond to those questions? They're probably questions that you guys have already thought about or encountered. So this presentation is seeking to help you answer those type of questions, and would submit that these type of questions are cornerstone questions. They're going to be things that define our culture. Also going to be, I think, the building blocks for liability as we go forward and we deal with lawsuits that are born out of the coronavirus world. All of these issues have legal consequences. That's why we care, right? That's why I'm talking about them. I'm not trying to step into the business world. I'm trying to say, hey, look, even these problems that we can't look to statutory law or case law, because there is none, for some concrete legal answers to these problems that we're dealing with, they still have legal consequences. Our business as in-house attorneys in your guys' situation, or out-house attorneys in my situation, I just love referring to myself as an out-house attorney. I don't know why. I just think it's funny. But our goal is to keep our employers from liability, for sure, and to keep them from having legal problems. What are the things that create legal problems? Certainly adverse employment actions, right? They always have, when somebody's terminated or there's been reductions in pay. And those things have happened during coronavirus. Even if they haven't been terminations, maybe they've been furloughs. So you have a lot of the building blocks for legal problems. Third bullet point, this is something we need to be really mindful of, especially when we're dealing with remote work issues, because we're going to deal with a lot of remote work issues. We can create legal problems when there's a perception out there that we allow one employee to do one thing, but not another employee to do the same thing. If there's a perception that working conditions are unsafe, that can be something that creates legal problems. When employees feel like they're not being heard, that can create legal problems. When there's poor communication, that can create legal problems. And I would submit to you those last two things. We're capable to respond to those things right now. And we need to put the type of culture in place where we can make sure that those feelings aren't out there. So what's at stake with coronavirus? Our culture is at stake, isn't it? We're going to be defined on some level in terms of how we respond to the coronavirus pandemic. Obviously we have to comply with the law, right? That's what the second bullet point says. I just don't think that's not going to open and shut all the problems that we have to deal with. There's going to be problems above and beyond what the law contemplates. We need to communicate with our employees and our customers about how we're going to keep them safe. I think that's a really important thing that we need to kind of go back to. It's going to be a good cornerstone to revisit whenever we're dealing with these non-legal issues and employees say things to you like I talked about in the prior hypotheticals where they're afraid about getting coronavirus. Look, everybody's afraid about that. No one's lining up to get coronavirus. But what we need to tell the employees, all the measures that we have in place to keep them safe. By pointing to those things, we can demonstrate to them that, hey, we care about them and that we're doing all we can do to keep them safe. And we're going to have to answer hard leave-based questions that there are not necessarily going to be legal answers to, and we're going to have to be careful not to craft or create legal problems by creating solutions to these problems. So just to kind of bring us full circle for what we started about, like Billy Joel in the song, we didn't start the fire. We didn't create this problem, but it's going to be up to us to fix it and solve it. So what is workplace culture, and does it matter? Of course, I would submit to you that workplace culture matters. That's kind of the thesis for my presentation to you today. But what is workplace culture? So it's not idealistic mission statements, okay? It's not aspirational goals about things you're striving to be or do. It's about tangible things, okay? It's about what we pay employees. It's about the benefits that we provide to them. It's how we create and enforce workplace rules. It's how we treat employees. It's how we respond to legal issues and non-legal issues as well. That is our company culture. And good culture is going to be helpful for us, isn't it? It's going to help us avoid lawsuits. It's going to help us retain good employees. It's going to help us attract desirable candidates and be successful and spend our time focusing on business and not focusing on dealing with legal problems. That's what we want to do. But I hope everybody hears me on this. Good culture is certainly not about always giving in. Okay, it's not always about giving in to employees. I think, and this is, anytime somebody tells you what they think, it's a little bit anecdotal. And so I'll tell you it's anecdotal on my end. I have talked with a lot of other attorneys who work in or practice in the labor and employment practice group at Burr, Foreman, McNair, and this is kind of a universal phenomenon that we feel like we're observing. We feel like employers may be giving in a little too much during the pandemic, and I think there are reasons for that. I think employers are scared. I think these are new issues, so there's no playbook in terms of how to deal with them. And again, part of what we're trying to talk about today is let's establish a playbook. Let's put together policies. Let's put together procedures. Let's think about these problems before they present themselves so we won't have to be so reactive. And I think also, you're dealing with companies who are in different financial situations than they thought they were going to be in as a result of coronavirus. There's just a lot of uncertainty. So we're seeing a lot. We feel like we're seeing a lot of situations where employers are giving in more than they would have traditionally when they're dealing with traditional FMLA issues or ADA issues or just general complaints. But good culture is not always about refusing employees' requests either, okay? It's not about that. It's about trying to get that balance, right? That work-life balance. I've heard of that myth for many years now. We're all chasing that. But it's about treating employees fairly and, of course, legally, and also, putting workplace rules in place that are going to keep employees safe and also optimize our business. That's what we want to do. That's the culture that we want to create. Communication, okay? I know everything's different at your workplace. I mean, it has to be, not everything, but there's substantial things that are different in your workplace. And what I would ask everybody is, have we communicated that to the employees? Have we let employees know what the new policies and protocols are? Should we? I think it's a fair question. I mean, should we do that? I think the answer is yes. If we look at the second bullet point, notification's a good thing to do just as a general rule, just to let employees know, hey, look, this is our new protocol. You're probably doing that by virtue of signs. Whenever employees come into the workplace, you probably have a sign that talks about like a temperature screen or mask requirement or the need to social distance, something like that. You probably have signs throughout your workplace. Maybe you have a computer pop-up that employees have to deal with in the morning, that they have to affirmatively state that they don't have a temperature and they haven't been around somebody with coronavirus. You may have those kind of things in place already. But is the signage is that enough? Because all the signage is doing is just saying, hey, look, there's a new protocol, right? We're taking employees' temperature now. To the extent you've got a temperature of over 100.4, then what, right? What are you going to do then? And I think that kind of brings us to the third bullet point. And if we have policies, it can be an affirmative way of protecting the employer from liability. There's been a lot of forecasting about lawsuits that are going to emanate from coronavirus. I don't pretend to know the answer to that, or I'm not going to try to be Nostradamus and make a bunch of predictions about that. But, historically, I know this. I think that there's a potential for disparate treatment allegations or discrimination allegations to arise from different circumstances that we're dealing with, whether it's remote work or, requiring people to go home for a certain duration of time because of elevated temperature or because of being exposed to people with coronavirus or even having coronavirus, whatever the case may be. There's what I would submit to you guys is like when we're dealing with temperature, for instance, it's a good example. There's only so many things that can happen when an employee comes to work in the morning and takes a temperature screen. The employee's either going to be under 100.4 or they're going to be over 100.4. So what are we going to do if somebody's over 100.4? That needs to be something that we write down, something that we can show somebody if there's a litigation and say, hey, look, this is our rule, okay? And we follow our rule. And also too, if you have a rule, it keeps, people from deviating from that rule. So it eliminates issues of discrimination and harassment, or it eliminates those type of problems. So, temperature is one good example. I think another good example is, what are we going to do when somebody tests positive for coronavirus? What's going to be our rule? How long do they have to stay out of work? Do they have to come back with a negative test? What's the deal going to be? Again, there's only so many scenarios that could happen when we're dealing with, a temperature over 100.4, or we're dealing with somebody who tests positive for coronavirus. We really are going to benefit by having a policy to say, hey, look, this is how we're going to deal with these situations. And also, too, maybe from like a mask perspective, we just will put employers on notice to say, hey, look, it's our requirement that you wear a mask when you're in the workplace, subject to exceptions, because there's always going to be some exceptions. And just to let employees know, if they don't follow that rule, then what? They can be subject to discipline. And of course, we're not going to box ourselves in terms of the discipline that we may hand out, but we're just going to say that the employee can be subject to discipline up to and including termination, something of that nature. But notification is important. Having policies is important. It encourages standardization, which again is important if we're trying to avoid lawsuits that are predicated on discrimination. Kind of put together sort of I've done a lot of these policies, talked with employers about, about the contents of those policies. And this is kind of a rough skeleton of what a policy would look like. If you have some screening procedures, you want to identify what those screening procedures are. If there are any sort of revised work rules, which there probably are, you're probably not going to let people come to work if they're displaying symptoms of COVID-19, or if they have an elevated temperature, then you need to identify those situations as well. You need to let employees know how you're dealing with visitors. And the last sort of bullet point there, it talks about workplace safety measures. You're going to let employees know what workplace safety measures you put in place, whether you're talking about masks, social distancing, hand washing, things of that nature. But you're going to let employees know what you're doing by virtue of a policy. Talked a little bit about this earlier in terms of the screening procedures. We want to let employees know in advance what the screening procedures are going to be in terms of temperature checks and the like. We talked also about posting those kind of notices, which my experience has been employers are doing a good job about posting notices on the door or throughout the workplace about that. And then if employees sent home, again, like we talked about a couple of slides ago, what you want to say in the policy is to say, well, hey, how are we going to deal with the situation if you have an elevated temperature? What are we going to do then? It's something that we need to think about now, and it's something that if we think about now, it's going to make it a little bit less on our plate when these situations happen over and over again, which I fear they may. So in terms of permissible screening procedures that the law is going to allow you to do, you can certainly question employees about their symptoms with coronavirus. I think you should do that. I mean, if an employee comes to you and they say, hey, look, I need to miss work because I'm going to go get a coronavirus test, I think you need to say, well, why are you going to get a coronavirus test? Do you display any symptoms of COVID-19? That's important to figure out from a paid leave perspective. Of course, employees can be entitled to paid leave if they are experiencing symptoms of coronavirus 19 and are seeking a medical diagnosis. I think one of the two things you can ask the employee are, what are your symptoms and when are you going to go have that test? That's important too. That employee needs to get that test as soon as possible. You want to follow CDC guidance on what COVID-19 symptoms are. There's been some variation in terms of what the symptoms are throughout the course of the pandemic. And you can ask questions as well to visitors who come in your workplace to the extent you're allowing them in the workplace. Measuring body temperature, okay, that's going to be okay. And we've got a slide that deals with this later on. Just know that if you're recording a bunch of data about the results from temperature, that's going to be a confidential medical record. So just think about that. Can you require a COVID-19 test? The answer is yes, you can do it. Can't require the antibody test. The Department of Labor has been very clear about that. There are a lot of problems with the antibody test. It's not as reliable as the test that determines whether or not somebody actively has the virus. So we can use that test, but we cannot use the antibody test. Right on cue, confidentiality of screening records. So temperature checks is a good example here. In the morning, If you're doing temperature screens, think about whether or not you want to keep all that data or what data you want to keep. It may just be that it makes the most sense to keep records if you have somebody who has an elevated temperature. That may be the most desirable thing, because if not, we're going to deal with a lot of paperwork, a lot of stuff that we have to treat as a confidential medical record. And of course, if it's a confidential medical record, that just means that we can't stick it in the employee personnel file. We're going to have to create a separate file that's going to be separate and apart from that standard personnel file. It's going to just be, one other thing to keep up with. And if we're, there may not be a point in having a backlog of what all your employees' temperatures are every day. You may just want to keep the record if somebody has an elevated temperature. Live training, I would submit to everybody that that's a good idea. It's been this way for years in terms of what the law is, because it used to be that we could just issue employee handbooks and it would give a certain affirmative defense, at least for like a hostile work environment claim. We could say, oh, look, we've got a handbook here, and the employee failed to take advantage of the protections of the handbook. To the extent they would have complained to us and let us know that this stuff was going on, we would have conducted an investigation like our handbook says, and we would have remedied the situation. Courts have said for a long time that's not good enough, okay? You just having a handbook is not going to be enough to entitle you to that affirmative defense under the hostile work environment claim or theory of discrimination. You're going to have to do more than that. And the courts are basically saying what we all kind of know: people don't read these employee handbooks. Courts have demanded more. They've demanded live in-person training. I think live in-person training is a good way to make sure that we're achieving good culture, right? Just to let employees know what we're doing, why we're doing it, let them ask questions. There's nothing wrong with that. We need to be prepared to respond. I don't think there's anything to be defensive about. Whatever we do, you're never going to get 100% approval, not in this day and age. I think we just need to be prepared to explain why we're doing what we're doing and to hear people out. I think that's another part of having a good culture. Employees challenging safety protocols. If you haven't had this happen to you yet, you're missing out on a lot of fun. That's the only way I know how to express that. And I said this just a second ago, and it's true. I mean, it doesn't matter what safety protocols you put in place. It's either going to be too much for some or too little for others, okay? There's no way to win. You're not going to be able to take a poll of all your employees and all your employees to be like, yes, my employers they're doing things perfectly. It's not realistic. It's not the way that things are going to work. What you need to think about in terms of what safety protocols you're putting in place is you need to have, again, a rational basis for it, but it needs to be a reflection of what you're seeing going on in society. I mean, if you're going to require a hazmat suit for employees to come to work, that's probably a little extreme. There's a lot of ordinances, even in South Carolina. I mean, we're to the point now where there's a lot of mask requirements. So requiring employees to wear masks at work, that's not a real far out thing. A lot of employers are doing that. Employers probably expect that sort of requirement at work. I think it's a good requirement to have. I mean, since the mask ordinances have been in place, our coronavirus numbers have gone down, which is great. Because as I mentioned earlier, we really want college football. At least some of us do. I'm in that camp. But when we're also talking about rules, social distancing, that's something that employees are going to expect. Temperature checks, again, that's something that employees are going to expect. Their employees are dealing with that, or a lot of employees are dealing with that, and that's become kind of the norm. And also, we're going to require employees to stay at home if they have any sort of symptoms of COVID-19 or if they've been exposed to COVID-19. All right, so employees who refuse to wear masks. So this could happen. I've seen a few different iterations of why employees have articulated their refusal to wear masks. Some employees just cite general freedom, right? They say, this is America, it's a free country, I can do what I want to do. Of course, we know that's not true, right? Freedom, like all sort of legal concepts, is a relative concept. Like, I've got the right to swing my fist, don't I? But it ends somewhere, at least where someone else's face begins. Maybe I've got more latitude in the Zoom world. But other employees cite religious reasons. Some employees cite disability reasons for reasons they can't wear a mask. Be prepared to engage in this process with the employee. Don't, my recommendation to you is don't just say okay to that, because it's important that we have safety measures in place to protect our workforce. That's an important part of the culture that we need to have in our workplace. And if an employee has an individualized issue, legitimate issue as to why they can't wear a certain type of mask, maybe they can wear a different kind of mask. Like if you can't wear, I've dealt with this situation, an employee has gotten a note back from their doctor saying, well, I can't wear a cloth mask because of whatever respiratory issue I have. Well, can you wear one of those face guards? Come to find out they could wear one of those like face guards. And they didn't like that as well, so they actually went back to the cloth mask. It's funny how that happens. But again, I think you need to treat this issue just like you would treat any other ADA issue, okay? You need to push the employee, ask, we need to know from the doctor, what are the reasons why you can't wear a mask and how long? Okay, there's no way you can't wear a mask for any time during the day. And there are all different types of masks that we can think about. If you're a manufacturing client, you can think about, maybe switching people around on the assembly line. There's a bunch of things we can do, but just be prepared to engage in this. This is going to be kind of the theme for this presentation, this individualized assessment, this interactive process with employees. So if you get any pushback from your employees, make sure that we're engaging in this interactive process. And also too, at the same breath, don't just dismiss it. Don't just say, hey, look, this is our rule. Okay, we want to keep people safe. You got to wear a mask all the time. That's not going to work either. If somebody brings a complaint to you, it's important that you think it through, that you ask that employee, again, why? What's the reason why you can't wear this mask? Let's put it in writing. Let's get you to sign it, okay? And then let's go through that accommodation process and let's figure out what we can do for the employee, to accommodate that employee's needs, but also to achieve our objective, which is safety. Could be that employees are going to say they don't want to take the temperature checks either. And, there could be many reasons for this as well. I think this is more of a black and white issue, but anytime that you have an employee who's saying they don't want to do something, I'm reticent to recommend that we just shut the employee down and just say, hey, look, this is what we're doing. I think there's a question that we need to ask. It's similar to when somebody comes to you with an ADA issue. It's always, how can I help you, right? Just that's a great way to start that conversation. In this situation, I've got a question for you to ask. Why? Well, why can't we take your temperature in the morning? What's the problem? We need to understand what the problem is with that. And of course, you're going to be able to tell the employee why it's important that we do that. Obviously, before February or March of this year, it wasn't something likely that you did. There's a legitimate reason for doing it. And of course, the law allows you to do that. And that's the big stick in this conversation. And there's nothing wrong with you telling the employee that, but maybe it's a question that we can handle, diplomatically. And also too, an employee who's not going to have their temperature checked in this kind of climate makes me think something else is going on too, right? Like, and maybe something else is going on. And by asking that question of why, maybe you can figure something else out. It's always good for us to resolve problems in the workplace. If we can do that, that's just one less, legal problem potentially that we're going to have to deal with, that we're going to have out-house attorneys deal with. And generally, taking a temperature check, it's not going to violate the ADA. You can do that, and you can require COVID-19 tests. You just can't require the antibody test. So the same kind of conversation you'd have with an employee to the extent they refuse to take a COVID-19 test. So talked a little bit about this earlier in terms of what, at least anecdotally, we're observing from employers. I don't think it's a situation where employers should roll over all the time. I know employers are scared. I know there's a lot changing and a lot changing fast, but some of these problems are old hat. I mean, some of these are just kind of old ADA type issues, and we just need to engage in that interactive process with the employee. And we need to figure out, what's going on, why they won't do a certain thing, why they won't follow our rule, and just kind of go from there and see if there's any legitimacy to it, see if we can't find some kind of middle ground. But, it's important now, probably more than ever, that we, claim the right to maintain rules in the workplace. Again, for safety purposes, that's important, but it's also going to be important for purposes of efficiency as well and productivity. Talked a lot actually about safety rules. I think I'm going to go back to this. I think I mentioned it earlier briefly, but I want to go back to this. There was a hypothetical that I set up at the beginning, and I was like, these are non-legal issues. And it was 2 examples of employees being scared to come to work because they were afraid they were going to get coronavirus because of their age or some sort of condition that they have or a loved one has that they live with. You know, how are you going to deal with that? I mean, I know we've had to deal with that a bunch. And, you know, one of the things that's been real effective is to talk about what we've done from a safety perspective to the employee. I think that's a really effective way to have that conversation. Sometimes that's the end of it. Sometimes it's not. If that's not the end of it, then, you know, these next series of slides are going to deal with remote work. We're going to be in a situation where we're going to analyze whether this is an employee who can work remotely or not, and all the problems associated with remote work. So let's talk about it. Without further ado, remote work. So the Families First Act is driving a lot of the remote work inquiry. We know, again, talked about it earlier, it's been talked about ad nauseum. I'm sure everybody who's listening on this presentation, lawyer or non-lawyer, is probably an expert on the leave entitlements associated with the Families First Act at this point. But the key, and people kind of overlook this requirement, people just think about the 6 qualifying conditions. They're important, but in order for an employee to be entitled to paid leave under the Families First Act, the employee has to be unable to work or telework, okay? So one of the things we have to figure out oftentimes is, are we dealing with an employee who can work remotely or telework? How are we going to deal with these requests? Let's face it, not everybody's going to be able to work remotely, okay? Your janitor, they have to come in. There's no way to do that job remotely. You know, people who are working, if you're a manufacturing entity, you know, a lot of those jobs are going to be in-person jobs, okay? That's where we're going to start our analysis. Anytime somebody makes the request to work remotely, we're going to say, you know, what is this employee doing from a work perspective? Is this a job that can be done remotely? And I'll add right now that a good thing to do right now is to take a look at those job descriptions. It's always a good thing to do. It's very tedious work. I know it's not high on anybody's priority list. It's hard work. There's been many times where people have asked me to do that. You know, you can't just talk to in-house counsel or HR people to do job descriptions. You got to go to the plant and talk to the people who are supervising and say, hey, look, is this tech person really doing this job? Is this essential? What do they do? And, you know, that's the only way to do job descriptions. It's hard to do that. It takes time out of supervisors' days as well. I know it's not high on anybody's priority list, but it's a good thing to do. It's always going to be evidence whenever we're dealing with an ADA issue about what essential job duties are. It's never going to carry the day, but it's always going to be evidence. It's always going to hurt you if it's not up to date, always. So I'm sure it's on everybody's to-do list, but just to add to it. So for telework, I mean, we're going to start off, we're going to look at your job and determine whether or not you can do that. And then there's the second part of the inquiry too. Maybe you've proven to us that you don't work remotely. I mean, it doesn't work. Like you're not producing deliverables or we're not satisfied with your job performance remotely. I'll add here too, you know, especially with school being not entirely open, I guess is the best way to articulate that. You need to think about what your remote work rules are going to be. You know, are you going to require uninterrupted time? There's a lot of things to ferret out and a lot of things to consider. And there's a lot of kind of give and take that can happen too, especially if you have kids who are attending school remotely. Maybe you're going to deal with an employee who's going to work a different schedule for you on a day-to-day basis just to accommodate, to accommodate that issue. There's a lot of things to think through. There's a lot of individualized assessment associated with these type of problems. Good news, okay? So if we've got somebody who wants to telework and we think it's close, we don't have to just say no because we're worried about what kind of precedent we're going to establish. The EEOC has said to us, hey, employers, we want you to try this out, okay? We want you to try it out temporarily. Okay, well, so let's try it out temporarily. And so if we're going to do that, look at the second bullet point. It's a really good recommendation, I think. let's identify this is going to be an interim basis or a trial basis, and let's say, hey, there's going to be an end date too. And let's make sure there's deliverables. There's going to be a slide, I think it may be the next one, that talks about supervision. What's not working from a remote work perspective seems to be that supervisors haven't really figured out how to supervise employees remotely. That's their job, okay? That's their job. They need to make sure that they check in with employees periodically, that they require deliverables. If that's not happening, it's the supervisor not doing his job. But make sure that we document this. If we're going to give somebody a temporary or trial accommodation, make sure that we document this. And again, right on cue, supervision. Supervision is so important in a remote work environment. We need to make sure that our supervisors are actually supervising. First bullet point, don't feel, just because you let somebody work remotely during March or April or whenever, don't feel like that's a forever thing. Okay, we can always say, hey, look, this is not working out. So long as there's a legitimate business reason for what we're doing, it needs to be documented just like always, because we don't want to fall into the trap of, well, hey, look, you're letting this employee work from home, but not this employee. There needs to be a legitimate reason as to why. I mean, there should be, and it should be something that you should be able to document. So if an employee is going to make a request to work remotely and we can't grant that request, we need to let the employee know why. Again, kind of good culture, just to let them know why. And we want to make it, and also it's a good way to kind of CYA, just so we can demonstrate to everybody why that decision has been made. And it could be that there's something individualized going on. It could be that, hey, you're the janitor and the janitor you can't do your job unless you're here. It could be that there's something else going on. It could be that the remote work environment where the employee wishes to work is just not one that's going to fit within your framework or within your rules. It could be that the employee is not meeting deliverables. This third bullet point is something I can't harp on enough. I think discrimination, harassment, retaliation, and hostile work environment, these are real things. These aren't made up things. But I can tell you this. A lot of the building blocks for those kind of claims are based on favoritism and inconsistency, clearly, all right? Because those claims at their heart are to say, I'm an employee and I was treated this way under these circumstances, and there's another employee and he has the same job that I have, the only difference is our race, and he was treated this way, okay? And a lot of times the explanation for the disparate treatment is not discrimination. It's, maybe the supervisor likes one of the employees better. That happens, unconscious bias, right? And sometimes it's just inconsistency. Maybe we feel bad for one employee, not the other. Maybe we know they're a single mother and they're doing the best they can, or whatever the case may be. But we always want to avoid favoritism and avoid inconsistency. We need policies that are going to contemplate remote work for a lot of reasons. We just sort of talked about some of the requirements that, there may be requirements for the environment that we're going to have in order for people to work remotely. There's also a problem, a big, big, big problem associated with hourly non-exempt employees working remotely. We need to have a policy that's clearly going to make them account for their time. This Fair Labor Standards Act is, of course, can be pretty nasty, especially as collective actions go. They're going to require employers to pay employees whether the work is authorized or not, okay? That's the way the law views it. It doesn't, the law defines work. It doesn't have to be hard. It doesn't have to take a long period of time. I mean, it can be as simple as just looking at emails on smartphones. Smartphones are, common culprits for these type of claims. And it could just be the employee answering a phone call, something of that nature. The Fair Labor Standards Act is going to make the employer on the hook if it suffers or permits employees to work. One of the things to think about is access. If we're going to let, hourly non-exempt employees work from home, are we going to give them access to our computer system all the time? Are we going to give them access to our smartphone email server all the time? Maybe we shouldn't. If there's a way to curtail that, then maybe that's a good idea. If we can't curtail it, let's maybe have a policy, and the policy is going to say, these are the hours in which you can access it. You can't access it more than 40 hours a week unless you've got advanced approval in writing to work overtime, something like that. Timekeeping policies are going to be really, really important, especially when people are working remotely. You probably want to reconsider however you're doing it, and you probably want the employee to do something affirmatively on a weekly basis to submit his or her time some kind of like boilerplate language that says, I certify this is, or acknowledge that this is all the time that I worked on this given work week. You know, employee's name, signs, scans it back to you. I think that's a good practice to have during the pandemic, especially if you have people who are working remotely. Okay, with overtime, big mistake a lot of times, and probably everybody knows this. To the extent you have an employee, you probably are going to have a policy about overtime as well, and you're going to say, look, employees can't work overtime unless it's approved in advance in writing. Well, if there's a violation of that policy, we still got to pay that overtime. We can discipline, but we still got to pay it. Okay, whether the work is authorized or not, we have to pay it. We talked about limiting access, which is a really good solution if you can do it. I can tell you right now, your IT people are going to tell you you can't. That's going to be too much work for them. Push back on them. You can. I've had employers who are doing it. They can do it. Think about expenses working from home. Okay, this is probably a pretty nebulous area of the law, but think about it. Think about whether or not the employees having to buy things to be able to work, whether it's a computer, internet connection, phone, whatever the case. You know, typically the employer is responsible for providing equipment to the employee wherever possible. So violating, anytime you're dealing with unauthorized work, you know, you're potentially running afoul of the Fair Labor Standards Act or South Carolina Payment of Wage Act. Both of these statutes are nasty. Under the Fair Labor Standards Act, of course, it can give rise to collective actions, which are similar to class action lawsuits. Payment of Wage Act claims can be class action lawsuits. I've defended a bunch of those. They're time consuming to defend. It can be very expensive. They can expose the employer to a lot of liability. So under both of these statutes, of course, you can recover attorney's fees, which is a fee shifter. Congress or the General Assembly in Columbia did that for a reason, of course, to incentivize attorneys to take these type of cases, but it can be a real disincentive for employers to defend against them. And we're not talking about just wages under either case. We're talking about liquidated damages under the Fair Labor Standards Act, which is basically the wages times 2, talking about potential treble damages under the Payment of Wage Act. So bad causes of action. And again, third bullet point, most of the time we're not dealing with insurance claims there. So we're dealing with a lot of attorney's fees on our end too, that we're having to pay our outhouse counsel to defend. Okay, it looks like we got about 10 minutes left too. So I think we're gonna leave 5 for questions. Kelsey, just tell me when we're at 5, because you know I'm a lawyer. I can fill up a bunch of time. It's one of my many gifts. So let's talk about.
You got it.
You got it. All right, thumbs up. Sometimes it's good on these presentations just to know somebody's out there. So I appreciate you popping on. And no, I'm not crazy and talking to myself for an hour. So EFMLA in schools. Have you guys heard any conversation about that? Probably none, right? So we've talked about this. I mean, you know, there's been a lot of discussion about the protections associated with the Families First law, okay, or Families First Act in terms of paid leave requirements. We know that employees can get up to 12 weeks if we're dealing with school or a child care facility is closed due to COVID-19 reasons. All right, we know that. A couple of observations for you. Number one, I mean, 12 weeks isn't a long time. I think, you know, we're starting to see a situation where employees are already burning through all this leave. And what are we going to do then, right? This law also is supposed to end December 31st, 2020. We'll see what happens there. But with school, you know, being remote, or maybe it'll be remote in the future. I don't know exactly where everybody is, and everywhere is kind of doing something different right now. But one of the phenomenons that we're experiencing already, and I think we're going to continue to experience, is employees burning through this 12 weeks of leave. If that happens, and you have an employee who can't come to work because of, let's say, because school is taking place virtually, okay, and they burn through all their 12 weeks of emergency family medical leave act, well, then we're going to be at this third bullet point, aren't we? That employee is not going to be legally entitled to any sort of leave. Maybe they've got some PTO, and you know they can get leave that way, but they're not going to be statutorily entitled to any sort of job protection or leave. What are we going to do in that circumstance? We can't just fire them all, right? I mean, it seems like that would be bad culture, for one. And it doesn't seem realistic. Most of the employees that are in our workforce, a lot of them have children. So how are we going to deal with this? The next slide kind of talks about it. Individualized assessment is kind of the way that we're dealing with this problem right now, akin to the interactive process under the ADA. So, and we're going to think about a lot of different things whenever we're engaging in that process. We're going to think about maybe offering unpaid leave to employees, maybe working a revised schedule, maybe some type of hybrid arrangement where employees work from home some and they come into the physical location some. So that's probably where we're trending, if we're not there already, is we're going to have to deal with some of these issues on an individualized basis. And we're going to have to be mindful when we're doing this, right? Because we're going to have to explain why we may treat one employee one way and another employee a different way. So we're going to have, it's going to require a lot of documentation. It's going to require a lot of talking with people, a lot of this sort of interactive process, which is tedious and time consuming. Yeah, I think, the slides, I think that says it pretty well. I mean, we're going to require people skills, right? In an era where we've really devalued these type of people skills. And this kind of brings me to this is good timing. It seems like I got a couple more minutes anyway, in terms of talking about how we can create a better culture. Better documentation is one way to create a better culture. We want supervisors to address issues with employees. I mean, the worst thing ever is for a supervisor to come to somebody in HR or for it to trickle its way up to the general counsel and say, hey, we got this issue with an employee and we're looking to terminate them. Or, we're dealing with outside counsel and we're looking to terminate somebody. And there's no documentation about the poor performance issue. And, the old rule, if it's not written down, it didn't happen, right? So we need to make sure that to the extent there are issues with performance, that those issues are being documented and that they're bringing them to the employee's attention, because we want people to get better, right? How are people going to know that they're doing something wrong if we're not going to tell them? Hey, and let the employee, if they disagree with it, let them object in writing. I think that's a good thing. That's a good policy to have. Nothing wrong with that. Let employees have their say. And of course, like we were talking about earlier in terms of the individualized assessment, we're going to document the need to address leave issues on an individualized basis. Want to make sure that our documentation is accurate. So again, this is kind of supervisor responsibility. Make sure that they're doing things the right way, and with HR people as well. We want to make sure that if they're dealing with an accommodation issue, that they're documenting everything in the way that they should. You probably have an open door policy in your handbook. If you don't, you should. I think it's a good idea. It's a good way to let employees, to give the employer the opportunity to try to address issues that employees have in the workplace before it becomes a lawsuit or before it becomes a legal problem. It can be a legal problem without being a lawsuit, of course, with people complaining to various administrative agencies. The whole idea behind HR, the whole idea behind employee handbooks, is we want to give ourselves the advantage to or the opportunity to try to solve those problems before they become legal problems. So let's do all we can to encourage employees to come forward with any sort of problems that they have. I think that's about perfect timing. I wish I could tell you that I planned it that way. I certainly did not, but I'm happy that it worked out. So it looks like we got 5 more minutes or so we can reserve those for questions. I don't have my chat feature pulled up, so let's see. Kelsey, do you see any questions?
I'm looking now, Jim. Yeah, so I'm looking at the Q&A now. I'm not seeing anything in there. So participants, I mean, if you'd like to submit via the chat, that's perfectly fine. You don't have to use that Q&A. And if we don't have any questions, that's also fine.
Yeah, it just means that I covered it.
Available.
It just means that I covered everything, right?
Correct.
Correct. That's what no questions mean.
All right. It looks like we're good. I don't see any questions coming in. And Jim, thanks again. Thank you so much for your time today. That was a very, very timely presentation given the circumstances. And we appreciate you as well as Burr Foreman McNair for sponsoring our chapter and just taking the time to present to us today.
Well, thanks for having me, Kelsey. I really enjoyed it.
Yes, and also participants, we will have a recording of this webinar as well as the presentation used today up on the Association of Corporate Counsel South Carolina chapter website. As soon as we can possibly get that up, we will for you to review. And I just saw, let's see here, John Works says thanks. You're welcome, John Works.
John.
All right. Well, I hope everyone has a great rest of your afternoon, and be sure to tune in for our next session and get registered for those upcoming sessions as well. Thank you.
Kelsey, I got a question for you before you leave. Aren't you supposed to give an answer or to something before we leave to a question? You said you were going to do that.
Yes. So at the end, the very end of this webinar, after we end, your screen is going to display a question for you to answer. It's very simple, but again, it's just to verify that you attended all the way through this webinar, and for CLE purposes, we'll report based on that question. And please use your real first and last name. We had a couple of people during last webinar who, I don't think it was their real name, but anyways, use your first and last name, answer that question, you're good to go.
Okay, thanks.
Bye.